Hey y'all, Rob here with ATX Legal, and today I'm going to talk a little bit about game theory and the art of war and how that has anything to do with the practice of law. So just to start out, this here is my worn copy of Sun Tzu's The Art of War. I've read it a dozen times at least. Most attorneys have read this because it does have a lot of helpful stuff in there, even though it was written ages ago. I don't know when exactly, but it has a lot of stuff that's still relevant today. And I'm going to start off with one quote from The Art of War. There's hundreds of great quotes, but here's one that has a lot of relevance. So, victory belongs to the side that scores the most in the temple calculations before battle. Defeat belongs to the side that scores the least in the temple calculations before battle. Most spells victory, least spells defeat, none sure defeat. I see it this way, and the outcome is apparent. Now, that might seem obvious, but what it's really saying is we can know the outcome of a battle, or in this case, trial, before the trial is even started. Because the side that is more prepared has the evidence on their side, that is going to be the side that is going to win. So obviously, Sun Tzu wasn't around at the time of game theory. It didn't come about until 1944. If you've seen the movie A Beautiful Mind, it's about John Nash, who really solidified game theory as a legit mathematical discipline. But Sun Tzu was already taking those principles in the art of war and applying them without knowing it. So in the context of a trial, if we can know the outcome before it's started, then why go through and have the trial? We can actually save costs on both sides, both for the defendant and the prosecutor, and this is why most cases do end in plea bargain. But for this to work, we have to make certain assumptions. So one of the assumptions is that we have perfect knowledge, and of course that's not actually the case. Sometimes the prosecution has knowledge that we don't have, sometimes we have knowledge that the prosecution doesn't have. So that could make a trial necessary because we don't have all the information we need on our side, or they don't have the information they need on their side. But laws passed in most states over the last 10 or 15 years have made it so that we as the defense get a lot more information about the case. It used to be that the offense report and other very important documents would be held back by the prosecution. Now we get these documents as a matter of course. In Texas it was called the Michael Morton Act, and it made a big difference for the evidence that we get from the prosecutors. And this has made it to where that knowledge is on a much more even playing field between the two parties. We know basically everything that the prosecutor knows, not everything, but a good chunk of it we have in front of us. And the reason for that law is pretty obvious. There were lots of people who were innocent who ended up being convicted because the prosecution was holding back important information. So we decided as a state, and really most states have decided, that it's just in the interest of justice that the prosecution needs to turn over that information, whether it's inculpatory, exculpatory, doesn't matter. They need to turn over that information to the defense, and that way all that information is out in the open. And what actually happens can benefit all parties, including the prosecutors here, because when both parties have the same information, it does enable us to come to a plea agreement in more cases and eliminate the need for trial. And when you eliminate the need for trial, it doesn't just help the defendant who's worried about his life and worried and all the stress that goes with a trial. It also helps the prosecutor because it eliminates their caseload and they don't have to spend so many resources on a trial. So showing that their hand and showing their information to the defense actually helps everybody. So game theory, I think most attorneys need to have a working knowledge of game theory. They don't go over it in law school. I took sort of self-taught my own course by watching YouTube videos. But in the case of criminal practice, you have this trial looming over everything. So that controls everything that happens with plea negotiations, even though 90 to 95% of cases, maybe even more than that, never make it to trial. The fact that that trial is there controls everything that does happen, because everything that we do in our plea negotiations with the prosecutor is sort of in anticipation of trial. What would happen at a trial? We're both sort of trying to figure that out based on the evidence that we have, based on the witnesses involved, and just everything involved with the case. And in addition to that, trial represents a cost for both parties, meaning we both have something to lose to go to trial. Therefore, the prosecutor can offer something lower than he would expect to get at trial, which benefits the defendant, but it also benefits the prosecutor because any case that he takes to trial is preventing him from taking another case to trial. So he has limited resources to go to trial. Therefore, everyone wins. The defense wins because we get an offer that's better than we would get if we would have gone to trial, and the prosecutor gets to eliminate one of the cases off of his docket so that he has more resources to spend elsewhere. So that's why when I have information that's favorable to my case, I'm often going to bring that information to the prosecutor if he doesn't know about it. We have to make a judgment call because if I do plan to take it to trial, it can be beneficial to hold that information back and spring it on the prosecutor when they're not expecting it. But in the case of plea bargaining, by giving that information over to the prosecutor early, we can sometimes eliminate the need for a trial altogether and come up with a better result and come up with it quicker, which most of my clients appreciate, and eliminate the stress and the costs of trial. So paradoxically, even though trials make up a very small fraction of all the cases that defense attorneys handle, the trial itself is the driver for a lot of the plea bargaining that goes on. All of that is in anticipation of what would happen if it did go to trial. And that's how game theory ties in, because we can know what would happen at trial to a reasonable certainty, not completely, but because we kind of know what would happen at trial, we can come to an agreement that serves both parties and everyone benefits. Now, what would happen if trials stopped existing? Well, unfortunately, we have a case study currently going on because of COVID. Starting in March of 2020, trials got paused. That was all across Texas, and in Travis County and in a few other counties, trials are still paused. And so we're getting to see firsthand what would happen if we didn't have trials. And what I'm seeing in my experience and in my practice is that it does affect plea bargaining. At first it didn't, because I think that there was a lot of unknown. Most people kind of expected the trials to come back shortly, maybe in a couple weeks, a month. No one expected the pandemic to last as long as it has. Now that it's been a couple years, it does seem that plea bargaining is affected, especially for clients who are in custody awaiting trial. These are the people who are definitely affected the most. If I have a client who is out on bond, yeah, it's not ever good to have pending charges hanging over your head, but it's a very different situation for a person that is in custody awaiting trial, in jail, could be innocent because he has not had his day in court. And the prosecutors don't have that. We don't have the ability to hold the prosecutor's feet to the flames with that trial, and you can't really simulate that. That's part of how game theory ties into this. The actual threat of the trial being there over the prosecutor's heads is what causes them to engage in plea bargaining. And when they don't have that, they are less likely to actually engage in plea bargaining, and your client sits in custody. Fortunately, most of my clients are out of custody, but for clients who are awaiting trial in jail, it's very significant, and I would call it lack of justice. I don't think that justice is being served right now during COVID. This video is not about politics, but I do want to point out that we are going to music venues, sporting events, bars. These are all open, which I would argue would be much more risk for transmitting COVID than trials. And why are we allowing these things to go on, whereas trials, which I think most people would argue are much more important, we're still holding back and not having those? I don't know the reasons for that. That's the commissioner's court of each county is who decides that. I don't know why Travis County is not going forward with trials now, but it does seem hypocritical to go forward with these other things that maybe are not essential to society and then hold back on trials. That's my opinion, but I think that many people would agree with that. For now, that's the environment we're dealing with. We deal with it the best we can. Try and find workarounds whenever we can. But the simple fact is that people are being denied justice right now. It isn't right, and it needs to change as soon as possible. Again, I'm Rob with ATX Legal. None of this is legal advice, but if you would like to have legal advice on your particular case, you can visit our website, atx.legal, or give us a call. Look forward to talking to you. Consultation is completely free, and I'll look for your call. Thanks.